So in the end, it comes down to if DCP&P comes knocking, lawyer up.
Absolutely, because even the first meeting, the first interview, the first visit, that sets the pathway for the rest of your case. I mean, if things start off poorly, it's hard to get back on track. If things start great, you stay on track. Because ultimately that worker, that division worker, DCP&P, make the findings. And that individual, the supervisor, the DAG, the people at DCP&P can, based on that finding, tear your life apart, tear your employment apart, prevent you from caring for your child financially.
Yeah, it seems it.
It's almost like it's a conundrum because DCPMP says you're substantiated, and now you can't work in a profession that you may have had or you used to provide for your kids. And now you can't provide for your kids. And they're going to say, oh, well, now you can't parent because you can't afford food for your kids. So it's almost a lose lose in that sense. So it's important at all costs to avoid that finding, to put yourself in a good light. Another thing, too, is look, if you have real concerns, right? We have clients who actually have concerns. Not everyone is a perfect parent, believe it or not, right? And
Of
so
course.
if you are a parent who you may say to me or your attorney, you know, I do have issues with alcohol or drugs or whatever else it may be proactive, address that issue, do the screens, do the treatment. If you really need the help, the more you do prior to that finding provides leverage to have that finding be lowered prior to it being made. Part of the factors is the parent progressing, complying with services prior to the finding being made. Once that finding is made, it's then made. That DCPMP office may change it through appeal or through further review, but it's important to try and be proactive and provide leverage prior to the finding being made. Because although findings can be changed down the road, the best outcome is not to have that finding in the first place.
No, of course. Now, how often are these findings actually substantiated?
Yeah, it's hard to put a number to it, right? A percentage, right? You have four findings. You might say, oh, well, a quarter there, quarter there, quarter here, quarter there. But it happens a lot. Fortunately, with our line of work here, we're able to have our clients oftentimes avoid that finding. But I also have many clients who come to me after the fact, say, "Oh, I need to appeal this or appeal that, or try and change something." Then, so it's common. Fortunately, when you have good counsel fighting for your rights before it's actually concluded the investigation. It's much rarer, I would say.
Okay, well, that's always good to hear. But let me ask this. When a case is substantiated, does that mean the children are then removed from that parent? Or do the parents potentially still keep their children depending on the severity of the finding?
It's a case by case basis. You have cases where people are substantiated, their kids are out of the house, or their kids are back in the home, or they're supervised. So there's no concrete answer saying if you have this finding, your kids will not be home. I've seen families who have those findings, kids are back in the home. There's no restrictions. They've addressed the issues that came up. The finding remains, which is not great, but the outcome of the case can still be a happy ending minus that finding being on your record.